one of the issues that people have, and one of the reasons that they end up hiring an attorney is because they're in an accident. They assume they're going to speak to the insurance carrier. The insurance carrier is going to do the right thing. They're going to compensate them for their vehicle, pay their rental, pay their medical, and soon enough they realize that's not the case. The insurance company is trying to lowball them, and they freak out, and that's when they contact an attorney. And even with us, there are some common tactics that the insurance companies will do to try to devalue cases. And I'll go over a few of them. So, they'll do what's called the low property damage valuation. They'll argue over treating. They'll argue non-compliance with treatment, or they'll argue that the injuries from the accident were pre-existing. So one at a time. So in terms of low property valuations, this is what they do. The insurance company will say that based on an image of the accident or the bullet vehicle or the vehicle that was hit, that they don't believe that this was an injury producing crash, and therefore you don't have a claim. And this is so common that the Department of Insurance in Arizona actually prohibited this practice and wrote a letter to insurance companies telling them this practice is prohibited. You cannot tell a person they're not injured because you look at a picture of a vehicle and you believe that shows that doesn't show enough property damage. The reality is that a lot of our vehicles, a lot of our newer vehicles, they have Mylar bumpers, they have this paint that can stretch, so you can crash into a vehicle and the bumper will bounce back. Even though on the bumper cover you don't see a lot of damage, underneath you'll actually have all the damage. So what you have to do is you have to repair that vehicle and look underneath to see if the energy absorption device or other parts of the vehicle are damaged. They usually are. But insurance companies will often try to extinguish a claim based on an image. If the vehicle doesn't show a lot of property damage on this image, they're going to try to argue that nobody could have been injured. And you have to remind them by sending them letters and by um, giving them the argument that what they're doing isn't in good faith. It's a prohibited practice, and they're putting their insured at risk, which is what they're actually doing. Another tactic that insurance carriers like to do is they like to argue that the person overtreated. They will argue, well, this person, again, the impact was so low. They'll argue the impact is too low, and this person should have gone to treatment only X amount of times. In Arizona, you take the plaintiff as you find them, right? If this person treated, if their doctor prescribed 2 weeks, 2 months of chiropractor treatment, physical therapy, who is an insurance adjuster to tell that provider that this person didn't need all that treatment? The insurance adjuster hasn't met the claimant, hasn't examined the claimant, but they're going to sit there and argue that, in their opinion, as an insurance adjuster, the opinion of the medical providers is wrong. So they're going to argue over treatment or that the person treated too much. Again, this is something that we commonly see. We have letters for. We need to remind them this is prohibited. You're not allowed to do this. Therefore, provide a fair evaluation. And by the way, inform your insured that you're doing this in case we have to file a lawsuit. And this goes into what's called a bad faith claim overall, which takes some time. It's rare, but you have to continuously put them in their place, right? To not let them run you over with their arguments. If you don't counter their arguments will win the day. You're going to end up with a low valuation, making litigation even more likely. So you have to really stay on top of them. Another common tactic is they're going to argue non-compliance with treatment. Imagine this: you're in an accident, you're rear-ended, and now you go to a provider. Maybe you're doing physical therapy, maybe you're receiving chiropractic treatment, and you're going to be receiving this for 3 times a week for the next 6 weeks, let's say. But you didn't choose to be in this accident. It wasn't your fault. You're in pain and you have obligations. Maybe you have children. Maybe you have a work schedule that's a bit hectic. So you miss a few appointments. Well, if your provider prescribed, let's say, 6 weeks of chiropractic or physical therapy, and you miss some appointments, the insurance company can argue that you were not in non-compliance with your treatment, and therefore you're at fault for not healing fast enough or for any other issues that happen down the road. Again, they need to take the plaintiff as they find them, right? You don't have an obligation to stop living your life to treat the way the insurance company wants you to treat. We're all busy. We all have a lot of obligations, and it's unfair and disingenuous for them to argue that you're not compliant with treatment because you had to take your child somewhere, or you had some type of family emergency and you didn't make it to your medical appointment that day, that somehow devalues your claim. That's just not fair. It's not right, and they're not supposed to do that. Um, and lastly, one of their tactics is this argument about pre-existing conditions. Again, you're in an accident, your rear ended, but let's say you had a back injury 1 year ago, 2 years ago, 5 years ago. When a claim is big enough, the insurance company is going to dig through your records, and they're going to argue that if you had a condition prior to this accident, that the accident didn't cause your damages, that this wasn't an injury that you had previously. Now, if you're in an accident and you were injured, even if it's a pre-existing condition, they're still responsible. They've aggravated this injury, so it's an aggravated damage. So it's again disingenuous, and they're going to want sometimes 5, 7 years worth of records from the past that um, just to prove that, or to argue that the crash itself didn't produce the injury, that the injury happened before. And you really have to be on top of that. You have to limit that. You have to use their own arguments against them. And what I mean by that is very often an insurance company is going to say, let's say you didn't treat for a week or two. Well, they're going to argue you weren't injured because, well, if you're injured, you would have treated. Well, you turn that back on them and you say, look, this person may have been injured 5 years ago, but she didn't treat again. That means, according to your own argument, that she wasn't injured. And you have to keep track of all their arguments, all their documentation to keep throwing it back in their face. The reality is they have an obligation to put the interest of its insured ahead of their own. They have to be fair to their insured. They have to protect their insured. Their insured was in an accident. It was their fault. They hit you. They have to protect their interest. Arguing low property valuations, arguing that you overtreated, that you're not compliant with treatment or pre-existing conditions, that does nothing to benefit their insured. It does the contrary. It makes us have to file a lawsuit oftentimes to correct these mistakes or to argue that their valuation was too low. So, in my mind, they're putting their interest, the insurance company's interest of paying less ahead of those of its insured, giving us a fair valuation for our claim. And that happens so often that if you're not well versed in this area, you can fall for the trap and find yourself in a lot of litigation as an attorney. But a layperson that's in their first accident doesn't know what to do and is trying to deal with an insurance company by themselves. It's just unfair what they're going to do, and they're at a loss. And we have many clients that come to us after several months of dealing with the insurance company, hoping that they were going to be reasonable with them, and when they're not, and they finally realize, you know what, I'm in over my head. These people do not have my best interest at heart. These people might not be dealing with me in good faith. That's when they call us. So it's really important. Anytime you're in an accident, talk to an attorney. You may not need to hire one. If you're not injured, you may want to get your property damage resolved as soon as possible. Get all your claims for property damage, loss of use, diminished value, get compensated for those, and move on. That's the best case scenario for anybody that's in an accident, that you weren't injured. That's great. You may not need an attorney, although you might need it for diminished value because insurance companies are loath to pay for that. But I think it's important to speak to an attorney to get an evaluation of your claim, because I know the tactics that they are going to use against a layperson. And knowing that is a huge part of representing somebody. It's not just proving our case, it's disproving the insurance company's arguments against our case. And that's such an important part of what we do as attorneys. So again, in an accident, call an attorney, get an evaluation. You may not need to hire them, but get an objective opinion as to what your case is, how it's going to proceed, how it may proceed, and who you're dealing with. We deal with hundreds of insurance companies, and we keep notes on all of them. We keep notes on the adjusters. We know what they're going to say before they're going to say it. I mean, it is funny. Sometimes you submit a claim and you can go almost word for word with what their arguments are going to be. Again, overtreating, noncompliance, pre-existing conditions, low property damage valuations. We have those templates, we have those letters, we have that language, and we have the plan on how to move forward if they insist on making those claims. So that's why, again, it's really important to speak to an attorney when you're in an accident. Even if you feel that you may want to carry it on by yourself, get an objective opinion.